Hello, everyone. This is Tom Fox back for another episode, and you're in for a treat today because not only do we have double trouble, we have double Johns. John's Gebauer and John Van Der Wal. Gentlemen, first of all, welcome and thank you so much for taking the time to visit with me today.
Thank you.
Good to be with you, Tom.
So I'm going to start with you, John Gebauer. Could you tell us your professional background and your current role?
Sure, happy to. I am currently the Chief Regulatory Officer for Comply. Prior to that, I've been with National Regulatory Services, or NRS, for the past 31 years and was president of that organization when we joined with Comply-Sci just about 2 years ago to form Comply.
So, John Gebauer, what does a chief regulatory officer do?
Well, funny thing is, one of the things that I do is make sure that I stay up on things like the rules that are changing. When I took on this role, little did I know that there was going to be mountains of change coming down the role. But we're having fun keeping track of it, and separately, Comply has a regulatory services arm where we do consulting and education for the marketplace, and that all reports to me. And John Van Der Wal is one of our senior consultants, so we're happy to be here.
Well, Mr. Van Der Wal, that would seem to be a natural segue into me asking you, could you tell me a little bit about your professional background and your current role at Comply?
Sure. Excuse me. Currently, I'm a senior director in what we call compliance advisory, which is part of regulatory services. I've been with the firm, NRS since 2014. Prior to that, I was with, oddly enough, compliance advisory services for 12 years. I was CCO in industry for a couple of years. Prior to that, I was when it was the NASD, I was a senior examiner out of San Francisco's district office. And I've worked in a whole host of environments in the financial services business, both on the sell side and the buy side. So yeah, right now again, as I said, I'm senior director, but that puts me in the field. I do a lot of audit work, exams, review of rules, compliance program reviews for clients that are assigned to my team.
So I'd like to now turn to the private fund reform rule and ask you guys what this rule is and what basically, well, let's start. What is the rule itself?
Well, let me start that out and just say, first off, it's somewhat of a misnomer because it's really 7 rules in one. The SEC gave us quite a prize in this rule. What they've done is looked at the practices that they've found in the industry, and they've come up with a set of new rules that they think will address some of the concerns that they have. Now, this is broken into the quarterly statement rule, the private fund audit rule, advisor-led secondaries rule, the books and records rule, restricted activities rule, and the preferential treatment rule, and not to be left out, the compliance rule, which applies to all advisors, not just private fund advisors. It is chock full of really important changes that is going to cause a lot of issues and concerns for the private fund industry over the next 2 years. And there's a lot that we can talk about in all of those sections. John, I'll turn to you and see if there's something in those rules that you want to highlight.
Yeah, a couple of things that have come up in working with and talking with clients and other compliance professionals, really on the audit rule and the quarterly statement rule seem to be where there's a lot of angst. The private fund rule, the private fund audit rule is very similar to the custody rule, where if I'm a private fund advisor, I can use the private fund exemption and have an annual financial audit done by an independent accounting firm or auditing firm that's registered with the PCAOB. And so that doesn't change for any firms that are currently using the audit provision in the custody rule. However, if you're an advisor to a private fund that's been relying on the surprise examination component of the custody rule, you're no longer going to be able to do that. And that could be very costly for these firms, especially when they have multiple separate funds that they're managing. On the quarterly statement rule, questions I'm getting really revolve around valuation, because you have to deliver your quarterly statements within 45 days of the quarter end. And then for your fiscal year end one, you have 90 days. Well, the audit, the custody rule and the audit rule still give me 120 days, but now for my fiscal year end, I have 90 days. So people are assessing and evaluating whether they can come up with accurate valuations in a timely fashion for their private funds to be able to meet these requirements. So there's a little angst around that.
How do you guys suggest or maybe even counsel clients on the implementation of these rules? Is it with a mixture of policies and procedures, changing? Is it training? Is it monitoring their staff to ensure compliance? All of the above, none of the above, or something different?
Mostly all of the above. The biggest issues that are here is really, first step is to take stock of what they have. So John didn't mention much about the preferential treatment rule, but the things that are common practices in the private fund industry, like side letters and preferential redemption rights or preferential information rights, are now things that can't be done the same way that they've traditionally been done. So the only way to understand how you're going to proceed is to know where the scope is right now within your current customer base, your investor base. And so we're advising firms to take inventory of all of the agreements that they have, to do a gap analysis and find out what needs to change in their existing documentation before they can then create their action plan for moving forward. In many cases, there's going to require, despite the fact that the rule talks about some legacy accommodations, we think that almost every firm is going to need to review and repaper almost all of their agreements anyway. So that's a complicated, long process for anyone, especially true for private funds. And so that's the step we're telling them to get started on right now, is that review of contracts and customer agreements and a gap analysis to decide what their go-forward plan is.
Is this something you feel like CCOs and or their staff can handle, or does this type of project really lend itself to outside expertise, either in terms of the expertise or the resource issue?
Well, at certain firms, it won't be too much of an issue, although there are things that they may need outside counsel's help with on interpretations or guidance on. But many of my clients have been getting together with members of finance, customer service, legal, portfolio management, and putting together a task force to tackle these issues, especially the larger fund complexes. This needs to be an all hands on deck type of a situation, because if you're a large fund, if you're an advisor to a large private fund or private funds in aggregate, you only have 12 months to comply with the preferential treatment standards, the restricted activities rule, and the other one, the advisor-led secondaries rule. You have 18 months for the private fund audit rule and the quarterly statements, but still, that's not a lot of time when you're talking about the amount of lifting they have to do. So you start by taking, like John said, taking note of what you have, taking inventory of your agreements. You're going to need that in two sections. You're going to need it in the statement presentation to reference governing documents. You're going to need it for the preferential treatment rule. You're going to need it for the restricted activities rule, because that deals with the fees and expenses that are getting allocated or charged to your funds and how that's handled. There's disclosure requirements, there's consent requirements for certain of the aspects of that rule, the restricted activities rule. So you got to get your arms around it.
I think there's also a bit of unknown at the moment. There's some uncertainties in the rules. I'll use one that has come up. There's in the preferential treatment rule, there's a clause that says that you can't have treatments that are preferential unless they apply to all investors of the fund or a similar pool of assets. And it's the or similar pool of assets is still meandering its way to what a commonly accepted interpretation is. It could be very narrowly interpreted, or it can be very broadly interpreted, and that is going to impact how you move forward, especially for larger, more complex advisors. And so, to answer your question, yeah, I think almost everyone that I know of is seeking outside guidance with attorneys and consultants for interpretation help. They are seeking outside guidance for best practice policies and procedures to be developed. And some of them are seeking input for actually helping them execute some of this work, some of the examination of the contracts and figuring out what that is. There's law firms that can help out quite a bit on that for them, reading through all their documents and coming up with a gap analysis for them.
Gents, I'd like to change the focus a little bit to insider trading, and maybe start with, are there any recent noteworthy cases on insider trading, and maybe even extend it back to 2023 that you guys are counseling clients on?
Yeah, I'll start that off. So there are plenty of cases. It's been one of the areas that's been highlighted in the examinations and enforcement by the SEC. A lot of them have to do with material non-public information leakage within firms. But interestingly enough, there's one that I like to talk about that actually shows no wrongdoing, but is a cautionary tale, I think, for the participants in this market. And it would be called the Jordan Meadows case, whereby Jordan Meadows was a trader at a broker-dealer who was dating a administrative assistant at an investment bank. And that administrative assistant was in charge of setting the schedule for the investment committee to determine final disposition of a transaction at the investment bank. During the pandemic, they were living together in an apartment, and Jordan Meadows came to know that this woman would walk the dog at a certain time and not log out of her computer. And during that time, he would investigate, open her schedule and see what was on the agenda and what the agenda notes were for the investment committee meetings. So, for example, if that investment committee was deciding whether to formally proceed with the acquisition of some company by another company, public companies, then that would create an opportunity for trading ahead of the transaction, which Mr. Meadows and several of his friends did. So neither the broker-dealer that Jordan Meadows worked for, nor the investment bank that the administrative assistant worked for was fined or even cited for doing anything wrong. However, Jordan Meadows was, but there's a confluence of cybersecurity and insider information, safeguarding, MNPI information that all happened in this case. And I tell customers that it's something that you have to really think about, going one step beyond what the obvious is and look a little bit deeper into your operations and see where leakage of that kind of information might be. So interesting case, but no wrongdoing charged.
So what are some of the key compliance solutions, if I could maybe pick up on that last point you raised, John Gebauer, what are some of the key compliance solutions you see that this case gives us as lessons? Is it to really perform a deep dive risk assessment or some other strategy?
Yeah, so definitely a risk assessment, but I also think there were probably signs, and unfortunately we have no close information, so we don't know how this was found. It was interesting, but there's also things that possibly could have happened at the broker dealer to identify unrealistic gains that were being had by Mr. Meadows trading, and investigate that. So personal trade monitoring is something that certainly comes into play for this case. On the investment bank side, I would expect that cybersecurity policies and general IT security policies should have noted that the information was being accessed inappropriately. Things were being emailed to other accounts. So there were places where email monitoring and communications, off-channel communications monitoring could have also caught things. So those are the two places where I think we could have employed tools to detect and deal with this.
Can you have a tool or perhaps even a tech solution that encompasses more simply than just a tool, which could take a look at a large amount of data to identify any red flags?
Well, you can, and my belief is that many firms do. They're deployed on the trading side of the house rather than on the compliance side of the house. And I think we're evolving over time where these models and this type of technology is now being deployed in the back office on compliance issues too. I think there's a lot of activity in this market currently on AI and machine learning that offers quite a lot of promise to both stop and detect inappropriate activity, but also to reduce the cost of compliance. I can't say that I think that these are very mature, but they are emerging. So we're gonna, maybe next year when we talk about this, they will have emerged and made a significant impact on the market. But it's new right now.
I'd like to turn now to pay to play and ask, as we move into, if not perpetual presidential election campaigning cycles, at least we've got one 18 months away, or I guess less than 18 months away. And why is the pay to play issue so important to be identified as a potential red flag or risk leading up to the 2024 presidential election? across the U.S.
John, you want to start that?
Oh, well, I mean, the amount of fundraising and campaign donations that happened in the midterms 2022 were about 2 billion more than they were in 2018, and we expect that to even be higher for our advisory clients that work with state and local governments and agency type clients managing their pensions, things of that nature. It's a great concern because if you make a political donation to somebody who can impact the decision of you getting a client, you can't get paid for 2 years. So you want to be on top of it first and foremost, but it has severe repercussions if you don't detect this practice, whether it's directly or indirectly contributed to somebody's campaign. So yeah, it's a big risk, especially if that's your marketplace.
Another area that I would say is related to today's political environment is the polarization that's out there has made it less popular for people to discuss politics in the office environment, and I think there's a resistance to reporting any donations for fear of that impacting how you're viewed by your organization. So that has added increased pressures for firms to be able to identify and locate these donations, whether they're reported or not. And there are tools that will allow your firms to search and monitor public databases for their employees, so that they can then deal with the donations, whether it was reported by the employee or not. So I think that's something we're seeing much more of, unreported donations by staff, and firms turning to tools more frequently to try and solve that particular problem.
Beyond setting policies and perhaps procedures and training on those, what's the role of the compliance professional in this arena?
Well, I can speak to that. It has to be a firm-wide effort, for one. I mean, you have to get buy-in from the top down. But wearing your compliance hat, you have, other than policies and procedures, you have to be proactive in trusting but verifying. And that's why I think these tools are very useful for me if I'm in that role, to be able to run searches so I can verify and document that I'm staying on top of that. If you fail to do that and somebody makes a contribution, you really don't have any cover. You're not a supervisor, right? There's going to be someone else for that, but you have to do checks to make sure that they're complying with your pay-to-play program.
What do you guys see as around the issue of pre-clearance in this area as well?
Well, it's going to depend on who your clients are, whether you want to go after that kind of business or not. So that's a big determinant on whether you would need pre-clearance or not. Some firms will only allow giving, at the de minimis levels, right? If it's someone you can vote for, it's what, $350. If you can't vote for them, it's $150. They're all doing 2-year lookbacks when they hire somebody to make sure that they don't have potential issues. But I think pre-clearance is a good thing if you're in the Govy space or you plan to be. You don't know where your clients are going to come from all the time, but if that's a space you think you might want to get into, then you want to have pre-clearance involved so you can help your associated persons comply with the rule. Not everybody understands. Like, can I give to a presidential election? yes, you can, unless that person that's running happens to be a state or local official that can impact the decision as to whether you get a Govy client or not. So it's helpful to have it in place to be able to help associated persons understand what's going on and not inadvertently make a mistake. And training, yes, absolutely. Training will help a lot too, as you mentioned earlier. And I think that's just to gain a greater understanding of what I'm responsible for, not just myself, but my spouse, right? Or partner, right? Living in the same household. They need to understand that as well.
It's critical for risk management, Tom. Not everyone at the firm is going to know very, very deeply all of the customers that the firm has, nor all the prospects that they have. And by doing pre-clearance, that's giving the firm an opportunity to avoid risk that may emerge downstream if a prospect, for example, is in a place where they're benefiting from that donation. So it's really a great practice. It saves the firm reputational risk downstream, and potentially having to unwind those situations. So yeah, we would always recommend that pre-clearance be part of the policy and procedure.
As we move to our final segment, I'd like to ask you to maybe put on your Karnak the Magnificent headwear and look down the road a little bit about some future rules you might expect to be adopted. So let me start with cybersecurity. Do you see cybersecurity rules in the cards for your arena?
Oh, absolutely. There are several measures, state and federal level, that are proposed at the moment, and I think at least the SEC's rule for advisors and funds is very likely to be adopted before the end of the year. I think that would certainly be one of the top contenders for the next critical area that the SEC turns their attention to. And like all new rules, it's going to cause cost and implementation issues for all of the registrants that it applies to. We'll see how it goes, but yeah, that's definitely on my hit list for the next ones.
Well, usually paired together with cybersecurity is data privacy. I'm not sure that pairing is always warranted, but I wanted to follow up cybersecurity or data protection with data privacy. Where do you see that down the road?
Closely coupled. There is a second data privacy specific rule, and it extends, for example, the definition of PII that we've all come to get comfortable with over the last, I don't know, maybe dozen years or so. And I think the biggest concern I have with the proposed rule is that it makes PII so broad that it captures so much more data and information that it will increase the chaos and the implementation costs that are required for probably little gain in actually safeguarding. Safeguarding, making sure that we safeguard and protect the information that we currently consider PII would be adequate, I think, at this venture.
Let me pick on that word chaos to introduce the next area, ESG. Will we have chaos? Will we have certainty? Will we have perhaps both?
Well, I don't think we're going to have chaos. I think what the SEC has found, and they've published in Risk Alert, is that firms are out there advertising or promoting or marketing that they're an ESG advisor. And then when they go in to see these, what's it, greenwashing or something? When they go in to see, visit the firms, and I ask this every time I go into a firm when I'm doing an annual review. If a firm is promoting that, say, okay, show me your documents and policies and procedures that demonstrate that you're an ESG advisor. Specifically, what do you do to screen, accounts, to screen investments? And are you documenting that? Is that process consistent with what you're marketing out there? So it's a big area. I think that there need to be more controls and more requirements for disclosure and policies and procedures in that space. And I feel that will eventually come down the pipeline, in the next 6 months.
How about outsourcing by investment advisors?
Yeah, the vendor due diligence rules, how I like to refer to it. And I think in those cases, we've been advising our clients to not only do initial due diligence, but also on at least an annual basis for riskier providers to revisit their due diligence and the effectiveness and performance of the vendors that they're using. But one of the major issues with this version of the proposal, the rule proposal, is it's going to require that you go to your vendors and have them agree to certain things about books and records that are required if you're an SEC advisor. I don't think Microsoft's going to change their agreement to work with me on that one. So this is going to be a sticky area. We'll see what happens with that.
Well, gents, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask each of you, if our listeners wanted more information on yourselves or any of the topics we've touched on, what would be the best place or places for them to go?
Yeah, the best place is either LinkedIn, search for the Comply business, and the comply.com website has all the information about the platforms, the consulting services, and the educational offerings that Comply can provide to investment advisors, private funds, broker-dealers, pretty much all registered market participants. And lots of information and resources on those locations too.
Well, Mr. Van Der Wal and Mr. Gebauer, I wanted to thank you both for taking the time to visit with me, and I hope we can continue this conversation.
Thank you, Tom. Look forward to it.
This is Tom Fox again. Thank you so much for listening to this episode of the award-winning FCPA Compliance Report. If you've enjoyed this podcast, I hope you'll subscribe, rate, and review wherever great podcasts are listened to. The FCPA Compliance Report is a part of the Compliance Podcast Network.